and the large area of the commerce. If you look at the title Indian Contract Act, then the Transfer of Property Act and the Limitation Act. I must tell you that broadly, the Contract Act and the Transfer of Property Act are substantial laws, while the Limitation Act is a fine fusion of the substantial and procedural law both. Because Limitation Act is concerned, it provides for the period of limitation for initiating any action. Basically, Limitation Act is the a provision or the position. It is a law which is prescribing the limitation for taking an action in remedial measures. So let us start in chronology. I will deal firstly with the Contract Act. And before I deal with the Contract Act, let me be very frank with you that the word, as a friend, as a lawman, I will request you that please don't use the word Indian hereafter, because the word Indian Contract Act is given in 1872 when the Britishers were ruling, I'm sorry, looting this nation for 250 years, and they were in need of this word Indian for their convenience. At least we, as the people having respect and dignity for our nation, I request you, I know I am not Guru, nor I can be claiming myself, but as a return gift, when this session is over, I expect you all not to use hereafter the word Indian, because in India, the Contract Act or the Sale of Goods Act or otherwise Evidence Act, now it is repealed, Succession Act, are bound to be Indian. So let us start working with one of the very important provision of the Contract Act, and I always call that to be Section 1 of the Contract Act. If you read the language of Contract Act, Section 1, it says, nothing herein contained shall affect the provisions of any statute, act, or regulation not hereby expressly repealed. So I always call the Contract Act is equivalent to the definition like a mithai. So Gulab Jamun is Sale of Goods Act. So type of the contract is essentially regulated by the Contract Act. This is not a topic on which I'm supposed to speak today, but if you look at the provisions of the Sale of Goods Act, it says that the Sale of Goods Act shall be applicable in addition to or in parallel co-extension with the Contract Act. So Contract Act is a larger canopy. It is a broader canopy under which the entire commercial world functions. So Contract Act is basically a largest canopy of the law which regulates every commercial contractual relationship occurring anywhere in Bharat or otherwise out of Bharat, when the international contracts are also being there. Primarily, the substantial law as applicable or prevailing in Bharat is the Contract Act. And therefore, this plays a very cardinal and extremely important role. Even if you are purchasing a refill in a ball pen or a Rafale which is flying high in the sky, both are regulated and controlled by the Contract Act. The Contract Act, therefore, has a very serious and a large scale impact. And therefore, we must read Section 1, which gives a kind of a very important mandate or direction. Generally, we have an understanding that the contract, when entered into the contract, generally in the today's world of commerce, trade, and industry, people prefer to prepare a written contract. But if you read Section 1, it says, nothing herein contained shall affect the provisions of any statute, act, or regulation, meaning thereby, in addition to Contract Act, other statutes are applicable. Giving a simple example, if I want to purchase a revolver, I don't wish, because my tongue is more powerful than the revolver. But if I want to purchase the revolver, then the Arms Act, Sale of Goods Act, and the Contract Act all are parallelly and simultaneously applicable. So it says the Contract Act is therefore a larger canopy, but in addition to Contract Act, other statutes or act as applicable. The revolver, as I told you, is a concept of the goods purchasable under the Sale of Goods Act, regulated by Contract Act, and also simultaneously enforced by the Arms Act. Therefore, the explanation, the Contract Act is applicable in addition to the other statutes and acts. But the important point which I'm trying to draw attention to all of you is, the regulation and act is understandable, but usage, custom of trade, or any incident of any contract. Friends, please remember the word incident of any contract. The word used in Section 1 of the Contract Act gives clear message. that even incident of the contract can become the effective tool to enforce or govern or regulate or operate the contract. Giving an example, suppose if you have employed somebody and the contract of employment says that your appointment as XYZ position as the clerk, as the accountant, you are supposed to remain present in the morning at 10:30. And if that employee writes a letter to you, I'm sorry, he writes a SMS to you or a WhatsApp to you that, dear sir, I'm every day coming in the morning in the office at 10 o'clock. But when I come, the system is not working. The office is not functional because our office peon or office assistant is not working effectively in time. Can you allow me to come instead of 10 at 10:30? And if you say yes, okay. Or nowadays people use, that thumb impression. The moment you write down your original term of the contract, that is you are required to remain present in the office at 10 o'clock, can be repealed. So incident of any contract is one of the important element. Believe me, therefore, the draft, a wonderful, nice, structured contract prepared by the lawyer shall be the tool which is in addition to the contract act. But the incident of a contract, so any correspondence, any communication, any kind of an incident happening in the contract is therefore extremely important. This is what it ultimately means. This leads us to another important area, which is technically known as the conception or formation of contract, which is provided for or regulated by section 2, 3, and 4 of the contract, or 2, 3, 4 to 6 of the contract act, because they are technically known as the elements regulating or governing the proposal and or acceptance. If you look at the language in this act, the following words and the meaning: when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other, such act or abstinence is said to make a proposal. So believe me, the proposal is a consideration for the person who is going to receive the proposal. If he receives the proposal and accepts that proposal, then the acceptance become consideration for the person who gives proposal. I know it sounds very technical. I give a very simple example. I go in a stationery shop and speak loudly that please give me the pencil is my proposal. The shopkeeper says, okay, I will sell you Nataraj pencil, give me 20 rupees. The acceptance of the proposal is concluded. But then believe me, this is something which is very, very bare and primary. Nowadays in the world where the things are happening with the help of the communication through electronic modes, you must also at this juncture connect yourself with the Information Technology Act, IT Act, which also attributes as to when the communication or acceptance of the proposal or acceptance is communicated. Of course, the traditional Contract Act, right, section 3, 4, and 5 gives the rules as to when the acceptance can be said to have been communicated, and when the acceptance is accepted, and then that constitutes the contract. So proposal and acceptance both put together, when two people agree on the same point in the same manner, then only it results into a formation of contract. Of course, at this juncture it is required to mention that there can be an invitation to offer. So instead of offer, what we call in the public government authorities, the government bodies, the public authorities like public institutions like Bharat Heavy Electronic Limited, Gujarat State Fertilizer Corporation, these are the people who invite the tender. That invitation, that NIT, what is popularly known, notice inviting tender, is not in any way an offer, because unless that offer is received and accepted, so NIT is a condition which is prior to proposal. If you look at the concept of section 2 subsection C and D, it says the person making the proposal is called a promiser and the person accepting the proposal is called a promisee. When at the desire of promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, the promise is to do or abstain from doing something, such act or abstinence is called consideration. So meaning thereby, I have a proposition, and in this proposition, to do is fine. I go in a stationery shop and I ask him that, sir, please give me the pencil, and I give him 10, 20 rupees or 50 rupees. He gives me the pencil. But abstinence from doing is also consideration which is being treated. Meaning thereby giving an example, if I am a five-star hotelier, enter in a contract with Mr. Sonu Nigam or somebody, and I tell him that I will pay you the X amount provided you will not perform in any other hotel. Now, therefore, the payment I make to him is a payment not only for performance and affirmative action, but a promise given in negative form that I will not perform, I will not act, or I will not do any dancing, singing for any other hotel. That is abstinence. So doing and not doing both are treated as consideration, meaning thereby if I have given a contract to somebody, then that particular person who may accept. One important reference which I believe requires, the promisee or any other person has done. So meaning thereby, if I have entered in a contract and if that contract is required to be performed by me, this language, either the promisee or any other person, this has a direct relationship, if my memory serves me right, with section 30, 30, mm, 13, I'm sorry, in chapter number 4, that is person by whom promise is to be performed. Normally we have an understanding that if I have a contract entered into with you, I will have to perform. But if you look the language and the shade of the meaning of section 2 subsection C, that the promisee or any other person, so meaning thereby I am a person who has entered in a contract with you, but any other person also can be said to be capable to perform. So meaning thereby this expands the privity of a contract. I have a contract with you, but today at 6 o'clock, if I would have had an emergency meeting with some senior counsel in Supreme Court, I may request my associate or my partner, Mr. Bhatt, to deliver the lecture. And if he delivers the lecture, and then that session also will be treated as my performance. Section 40 of the contract that says, if it appears from the nature of the case that it was the intention of the parties to any contract that any promise contained in it should be performed by the promiser himself, such promise must be performed by the promiser. In other cases, so if I am Sonu Nigam, I cannot replace a singer. But in any other case, the promiser or his representative may employ a competent person to perform it. So if I am a lawyer engaged by you to argue, sometimes I do not have a time and I may write an email to you that instead of me, my associate senior partner would go and argue, and his argument would be treated as an argument on behalf of me. So this is the shade which I always call the defining provisions of the Contract Act are therefore having a consequential effect in the operation of the Contract Act. Performance in the contract is extremely cardinal. Technically, performance should be given by the person who has entered in a contract. The Contract Act provides a liberty that any other person other than the person who has entered in the contract also can perform, and that performance can be said to be effective performance for the purposes of contract. This is an expansion of the contract performance. I know we are at the stage of we are at the stage of formation or conception of a contract. This leads us to attend two more important sections, namely communication, acceptance, and revocation of proposal. The communication of proposal, the acceptance of proposal, and the revocation of proposal and acceptances respectively are deemed to be made by any act or omission of the party proposing, accepting, revoking, by which he intends. Now, if you look at the language, I'm not going to discuss in detail as to how the revocation is, but the language of the law is very clear. There should be an act of the parties. A small, not A big, because you know well that this is a foreign language where big or the capital A converts the sound act into an enactment or the statute. And any act means ऐसा कोई भी कृत्य, कोई भी एक्शन, कोई भी कृति, એવી કોઈ પણ કાર્યવાહી જેનાથી you can communicate either acceptance of proposal or otherwise revocation of the proposal that is required to be judged from the action you have entered into. And this leads therefore an important element of understanding, that please understand friends, that whenever there is a contract is getting conceived, you should be extremely careful, meaning thereby the click wrap contracts at this juncture it is required to refer the IT Act, because the traditional concept of acceptance of the communication or acceptance of the proposal or revocation of the proposal requires some act. You must all read the provisions I'm sorry, the provisions of the Information Technology Act, which specifically provides for the provisions as to when there is a fusion between the Contract Act and the Information Technology Act. We are all aware about the click wrap contract. The moment you open your Google account, you say I agree. That word agree. No, I'm sorry, it was in need of a water. So coming back to the issue, the IT Act is a law which you must all read when you want to understand the concept of chapter 1 about the communication acceptance. Then if you look at section 4, the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. This line has an importance because nowadays either it is SMS, WhatsApp, or email. If you go to the IT Act, it says the communication is complete when it enters into the computer source to which it is intended to be sent. This is the language. I do not have IT Act in front of me, but 99% when it enters into the source of the computer, when it enters into the source computer to which it is intended, meaning thereby read receipt is a concept which we all use nowadays in technology. So you should be careful when it comes to question of contract coupled with the operation of the IT Act together. This leads us to another important element which says that revocation how made. Revocation of proposal and acceptance, section 5 and 6, it says by the communication of notice of revocation by the proposer to the other party. Naturally, the moment word notice comes, the people immediately will remember a brilliant letter pad, signed lawyer's signature. No. The word notice is is rooted in the word note. When I was a school student, my teacher used to ask me, Mr. Suman, did you take note of it? So the word note is mental process. The moment it is required to be communicated, the communication is required to be acknowledged through the mental action of taking note. I'm not reading the remaining part of the it, but when there are condition precedent which are required to be fulfilled for acceptance, if it is not done, there are other conditions. But important element with which I believe I must deal with, that whenever there is an acceptance should be absolute, meaning thereby if you have sent me the proposal on my mobile, dear sir, namaste, I propose to sell my old motorcycle Java for rupees 15,000 and I can give you delivery in 2 days. If I write, I accept provided you give me the delivery in 1 day, it is not an acceptance. So meaning thereby there should be an element of ad idem. An element of ad idem in the contract is when both the persons agree on the same thing in the same manner, then it is ad idem. So that element is enshrined in section 7, that acceptance must be absolute. It should be expressed in some usual and reasonable manner. As I told you, the expression of acceptance is important. It is the expression of the person which creates the contract, and it very clearly, very absolutely in a loud word, it is stated that it should be expressed in some usual and reasonable manner, unless the proposal prescribes the manner in which it is to be accepted. So there are contracts, especially the government contracts, which says that when you want to accept the proposal, the acceptance of the proposal, so there is an invitation of tender by ONGC, the tender has been accepted, and upon acceptance it is mentioned that within 20 days you are supposed to deposit the amount of performance guarantee or the security guarantee. If you don't deposit that amount in the prescribed time, notwithstanding that you have given offer, your offer is accepted, you are L1, even then the contract cannot culminate because you have not performed the condition as attached to the acceptance. These are the major pillars on which the journey of the contract depends and decides. Then if you look at one other important section, I always give the importance to this section because for one very simple there is continuous flickering of some people entering into the meeting, and it causes disturbance to my screen. It says you admit. Should I admit or somebody is going to admit it?
सर I'm admitting them, but वो थोड़ा network के कारण शायद हो रहा है. Sorry sir.
ठीक, कोई No, no, don't say sorry. No, another thing, going from law to life, ये sorry और thank you, ये अंग्रेजों ने सिखाई हुई ऐसी दो शब्दों की माया जाल है जिससे हमारा अंतर बहुत बढ़ता है. तो बहन जी विनती है, आप मेरे से sorry thank you मत कहिए. With all respect to reality, let us go ahead because I am part of you. You should be part of my life. Let us move on. Section 9. Friends, please remember, Section 9 is one of the most important element. I always say the Contract Act does not provide for any specific form of the contract. There is no formality prescribed by the Contract Act. And please remember, when I make this statement, I am aware that whenever there is a specific nature of contract, meaning thereby the contract for immovable property, the provisions of the Registration Act, the provisions of the Stamp Act, all those provisions would be attracted. But Contract Act as a parent law does not provide that whenever there is a contract, it should be in writing, prepared by the brilliant lawyers, signed and structured with all those round seals and notarization nowhere. So the form is not important. The Contract Act therefore recognizes the formation of contract in the oral form. When I say yes, if you look at it today, if I want to sell my small flat worth 15-20 lakhs, I will have to register the document. But the very contract, if it is related to the sale of cryogenic tanks by my client to somebody, maybe worth around 50 crore rupees. So my flat worth 15 lakhs may require an essential documentation, registration, procedural formality. But if I am selling the cryogenic tanks for the purposes of ISRO, I may not be required to register an ordinary invoice with a delivery challan coupled with the e-way bill issued for and under the GST Act can conclude the contract. I'm just trying to expand the effect of Section 9 insofar as the proposal or acceptance of any promise is made in words, the promise is said to be expressed insofar as such proposal or acceptance is made. Otherwise, then in words, the promise is said to be implied. I believe all friends are aware that implied and express, the effect of implication is same, the effect of expression is same. Lighter part of the story, not a real life story. I was in a college, was really in, having a great liking for a beautiful girl. On 14 February, a useless day where people believe that the only day to love, I go and give a card to her, I love you, express, I continue to look at her and try to impress upon her, is a implied. I'm just trying to give a lighter part of the story. When I express myself through some means, it is expressed. When I express myself through my conduct, it is implied. Believe me, friends, Section 9 therefore gives a very loud message that whenever you are in a contractual relationship, you should be very careful for the purposes of your action, conduct, communication, correspondence. And if you are not careful, believe me, you are accepting something in the contract. Giving an example, suppose if I am a painting contractor retained by Reliance and I give example which are having real life relationship in the courtroom, I expect that the group before whom I am there or lawmen maintain confidentiality of a privileged communication. There is a contract by Reliance with the painting contractor, and the painting contractor writes that I have painted your outer surface of the plant, but part of the contract you were required to provide the fans with 250 rpm speed, then only the painted premises or the painted surface would get dry, provided you are providing the fan, and the fans you are provided are not 250 but 150 rpm. So you will have to keep the fans on for 50% more time than the time I have prescribed. Reliance engineer, project engineer writes, thank you, Mr. Suman, very much for your technical suggestion. We understand that our fan speeds are not good. Therefore, we shall follow your instruction. Original term of the contract that the contractor shall complete the painting and the surface shall be dried up within the period of 20 days will get modified because impliedly you have accepted that there is a term which is contract which is changed as you have accepted. I'm just trying to tell you that there can be an implied acceptance of the term or implied acceptance of the modification of the contract. If we are good with this, we should move on some more important and equally more operational provision, because the provisions with which I dealt with friends was related to the formation and conception of contract. It says what agreements are contract, essential ingredients in the contract. Every agreement may not be the contract, but every contract is agreement. I repeat, every agreement may not be a contract, but every contract is essential an agreement. The word agreement means two people agree together. Today in the morning, while I was coming to my office, my wife told me that let us go and have a coffee tonight in a coffee shop. I said yes, it is an agreement but not contract, because essential elements of consideration, essential elements of consent being, I'm sorry, later consent being free, because my wife told me I have no choice. But I say yes, yes, okay, I'll come and join in the coffee shop. So meaning thereby, with all respect, the contracts and agreements, I say therefore every gulab jamun is mithai, but every mithai is not gulab jamun. That is the material difference between agreement and contract. All agreements are contracts if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. There are elements which are provided that they make contract bad in law, because the heart, the soul, the parent of the contract is a consent. And when there is a consent being given, if the consent is being affected by any of the elements go provided in and defined in, provided in section 12 onwards, so 11, 12, 13, 14, 16, 17, then the consent is treated and considered to be not free. Take me in a very right spirit. I'm an employee in some organization, and I have received a notice that you are required to be transferred from Vadodara to Assam. And I say, sir, it's very difficult. I cannot go to Assam. And then there is a correspondence. Or with full respect, I have some difficulty with with one of my boss who is not behaving properly. There is an intra-office communication between the employee and the employer, confirming that the employer and employee are in serious dispute. And then one fine morning, I have been asked to sign the resignation letter. If I am able to show, when I say I am able to show, a good lawyer can direct such employee that if I resign on the paper, I'll go out of the organization, of the premises of the company, and will write it to my boss. Dear Mr. So and so, thank you very much for exerting a wonderful pressure. Believe me, in the life you may not suffer. I'm sorry, in the law you may not suffer, but in the life you will suffer. Karmana ફળ કોઈને છોડતા નથી. I write a SMS or a WhatsApp. Believe me, my consent may not be treated free. So whenever consent is affected by some element as listed in the Contract Act, the person is not sound mind. The free consent is not free consent when it is affected by the coercion, by undue influence, fraud, misrepresentation, or mistake. These are the elements which are broadly covered. But if you ask the genetic cause of all these elements, they are all capable to affect the free consent of the person. So if I'm signing the contract, if it is not signed with the willful freedom of the person, the contract doesn't come into force. I must at this juncture bring a reference to section 23 of the Contract Act, which very specifically says, please excuse me if I'm moving on with little more speed, but because I'm required to cover two more laws. Section 23 says that the consideration or object of an agreement is lawful unless it is forbidden by law, or of such nature, or of fraudulent, or involves implied injury, वगैरह वगैरह. So meaning thereby, section 23 is popularly known as public policy. When the contract is bad in law, it is not only the concept, but when the contract is having an effect of violating some law or affecting somebody or doing some forbidden action in law, even then the contract is bad. I'm just trying to point out that formation of a contract has therefore two elements. The formation can be affected at the root level in consent. It can also be affected and can be said to be bad in law because of the nature, operation, and governance of the contract. This leads us to another two concepts. One is contract or agreement becoming or being void and voidable. You must understand primarily two concepts. They are being dealt with by section 24, 25 onwards. It very clearly says that whenever The consideration, if any part of the single consideration of one or more object or any or one of them or several consideration for a single object is unlawful, the agreement is void. Meaning thereby the void and voidable material difference is the contract by its formation, by its ingredients is void, but sometimes it is voidable. The voidable is voidability, the competence conferred by law on the person to avoid the same. At that time, it can be said to be voidable. Meaning, thereby, I gave the example that I have been compelled to resign. So bringing an end to the contract is not my willful action. If I wish that the agreement, if I wish that the resignation given by me is an agreement because I agreed to resign and you as an employer, you accepted my resignation, in that case, I can file a suit to declare or seek the cancellation of document as it is voidable. Section 31 of the Specific Relief Act provides for the remedy that if I find any document to be voidable, at that time I can file a suit for cancellation of document or otherwise getting the contract being avoided or otherwise making me entitled for making it voidable. This leads us to another important element, agreements by way of wager. But however, you must know well that nowadays in the industry, the contracts which are wager, but wager is 100%, it is related to the element which is uncertain. Agreement by way of wager are void, and no suit shall be brought for recovering anything alleged to be won by any wager entrusted. But I must tell you that nowadays there are contracts happening between consultants or otherwise the research fellow or scientist, that they will develop one particular product. There are different levels of the different products or research area, and the scientist or consultant is able to achieve some benchmark, then that is considered to be achievable and non-wager contract. Technically the achievement is on the basis of the parameters of the industry, so those contracts are accepted by them. Then comes another important area which is known as contingent contract. The contingent contract, the classic example of contingent contract is contract of insurance. It very clearly says the contingent contracts, to do or not to do anything of certain future event happens, cannot be enforced unless that event has happened. I have entered in the contract of insurance. I am sure many of you also must be having the life insurance contract. The life insurance contract becomes enforceable when that event occurs. Jare manas, when the person leaves from the chair and goes into the photo frame, the contract of insurance of life comes into force. When the contract of insurance for the vehicle, if you are driving a vehicle, if it suffers a damage on account of somebody dashing with you, it is a contingent contract. So contingent contracts are one of the important type of the contract recognized by the law, and that is being dealt with in chapter 3. Of course, the contingent contracts, their enforceability are also important element. One of the principles says that if the contract is contingent and if it is impossible because it depends upon the future event which is not going to happen or which is not likely to happen, at that time at the choice and option of the person in the contract, he can avoid it. Then comes most important area of law, which is, because see, the entire contract act, friends, is divided into primarily the two divisions. One I call the substantial law of the contract act, and another is the procedural part of the contract act, which deals with the specific types of contract, which starts dealing with the indemnity, guarantee, agency. They are the types of contract. As I have told you, the Sale of Goods Act, originally it was part of Contract Act, by section 76 to 123 being removed from Contract Act, and the new act is created, namely the Sale of Goods Act. Likewise, the contract of indemnity, contract of guarantee, contract of agency, contract of bailment, these are the specific types of contract, friends, which are being provided for by the purposes of operation of the Contract Act. Let me deal with you primarily, therefore, the substantial part of the Contract Act, and that substantial part, in my opinion, I always call the fountain source or the soul of the contract. If Under section 2, 3, and 4, if the contract is getting conceived, then the full time pregnancy child delivery takes place when there is a performance of the contract, because I always believe that the performance of a contract is the object for which the contracts are entered into. No industry, no commercial world will say that I want to learn, I want to understand how the brilliant contracts are being drafted by the Satyavidya and company, therefore I am going to Mr. Suman to draft the contract. No, 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 no. The contracts are entered into for advancing, moving ahead, or creating the commercial contractual life so that the world of industry and commerce moves on. And that is where chapter 4 of the Contract Act, I always give emphasize that this chapter has a very cardinal role to play, and that is performance of contract. If you look at the provisions, they are very innovative and energetic. Normally the moment we use the word performance of a contract, you or anybody would expect that I should give the physical performance. But if you look at the language of section 37, it says even ready, available expression to complete the performance is equal to performance. If I put it in a very simple language, that I have to pay you 5,000 rupees, there is a contract between us through a promissory note. Negotiable instrument is also contract. I have borrowed money from you. God wishes that that time should not come. But if I have borrowed money from Mr. Jayant and I tell him that Mr. Jayant, I will pay you 5,000 rupees, because Mr. Jayant is in the business of earning, revenue out of interest on 5,000 rupees, I am required to pay him some interest every month. For example, I am required to pay him 500 rupees. Let us not go into the commercial propriety of that word, but then I am required to pay him 500 rupees. Every month, I should pay him 500 rupees on the interest for 5,000 rupees or 10,000 rupees. Every month, last date, 30th or 31st English calendar month, I will pay him the interest. For 7 months, I paid the interest, and then I realized that it is better to earn and work hard than to borrow the money from than to borrow the money from the private shroff. I go to Mr. Jayant and tell him that, sir, I am coming tomorrow to repay your money. Tomorrow is 29th of June, 29th of July, so that our contract ends. I am not required to pay the amount of interest. So the provision says at any time before the month ends, if I refund and repay the money, then I am not liable to pay the amount of interest. I go in the morning on 30th or 31st. Mr. Jayant is not available. He has locked the premises. I call him. He said, मैं अभी बाहर गया हूँ. You come kindly later on. I send him the wonderful selfie with a bulk of money, smiling face of Mahatma Gandhi, that I am ready to pay you rupees 5,000 rupees. Please come and collect from my home. The cash amount is available, readily payable by me to you today itself. This SMS, WhatsApp with a wonderful selfie and the currency note in my pocket is equal to actual payment. I know it is something which is very, unique, that I actually give you the payment, you receive the payment is different than the readiness expressed, but that is the language. The parties to a contract must either perform or offer to perform their respective promises. The word offer to perform expands the scope of the concept of performance. I don't need to always perform. My ready offer to perform is equal to actual performance. Such performance is dispensed with or excused under the provisions of this act or any other law. There the root or the soul lies of section 54, 53, 55 of the Contract Act. The language says the performance is dispensed with or excused under the provisions of this act. Please excuse me for a minute. Yes. The question comes how a contract can give you the dispensation. How the contract can give you the dispensation of the performance? If you read the language of section 54 of the Contract Act, I believe you will be able to understand the heart of the word, that party is required to perform or offer to perform unless you are excused or dispensed with by the contract. You read the language of section 54. I always believe that a law is like a symphony in the band or a symphony or harmony in the music. They are all intra-connected. Section 54 says when a contract consists of reciprocal promises such that one of them cannot be performed or that its performance cannot be claimed till the other has been performed and the promiser or promisee last mentioned fails to perform it, be with this language, such promiser cannot claim the performance of the reciprocal promise and must make the compensation to the other party. I am dispensed with my performance in a contract. The example I'm giving you is very, very subjective. It has nothing to do. Jayant contacted me and said that, Mr. Suman, can you conduct a session on Contract Act? I said yes. His proposal is being accepted by me. We should start session at 6 o'clock. I gave a WhatsApp SMS message to him that I am ready to enter into the network. Please let me know. And at 6 o'clock sharp, I entered in. Jayant is not able to get the network connectivity. Credit goes to Geo or any other network. The internet connectivity is not there. I am dispensed by giving any performance beyond 610 or 615. This is what the effect of section 54. Unless prior performance of ready internet is provided, my session with you cannot continue. Therefore, my performance is dispensed with by the language of law. 54 and 37 goes together. I must perform my obligation, and unless my offer and readiness is not there, or alternatively, I am being released from the obligation. Language of section 54 very clearly says, and the promiser cannot claim the performance of the reciprocal promise. Can JNG expect a performance from me if it doesn't provide me the internet connectivity and the meeting connectivity or the link? I'm just trying to show the interlinking bridges between different provisions of law. Then comes section 38, where the promiser has made an offer to offer a performance of the promisee, and the offer has not been accepted. The promiser is not responsible for non-performance, nor does he thereby lose his rights under the contract. Again, there is a shade of section 53 that when there is a reciprocity in a contract, the relationship is like a chain. One link is another link of the contract. My promise depends upon your prior promise. Now, what is the prior and what is the subsequent? That is also being dealt with in the chronology of provisions, and in particular section 51 and 52. These two sections very clearly communicate that what is the chronology of performance. Anukram, which promise shall be performed first, which promise shall be performed later, that depends upon the subject matter of the contract. When a contract consists of reciprocal promises to be simultaneously performed, no promiser need perform his promise unless the promise is ready and willing to perform. Section 52, order of performance of reciprocal promises. Order chronology, anukramanika, where the order in which reciprocal promises are to be performed is expressly fixed by the contract. First two lines of section 52 lays an importance that when you want to draw the contract, you can put the chronology that you will do this first, I will do this next, I will do next, then again you will do this. If you write the chronology in the written contract, for that a lawyer must, with all respect, become part of the contract operation and can give the chronology. But if it is not given in the express terms of contract, then they shall be performed in that order. Where the order is not expressly fixed by the contract, they shall be performed in an order which is applicable to the nature of contract. The nature and the subject of the contract would therefore guide that which performance is required to be performed in priority. Therefore, advisably, when you want to have a contract, the chronology can be very well mentioned. This leads us to another important provision of law relating to the performance of contract, which I have earlier referred, that is person by whom the performance is given. Of course, I must also bring to your kind notice one of the important element, that performance can be with the person or through the person who is not a party to the contract. One more shade, when a promisee accepts performance of the promise from a third person, he cannot afterwards enforce it against the promiser. The best example is available in the world of commerce. I am entitled to recover 50,000, 5 lakh rupees from the defendant. Then the defendant tells that, sir, I am entitled to get, say, 2 lakh rupees from some industry. You kindly get it from him. And if I receive it from the person who is not a party to the suit, even then it can be treated as a liability being discharged by the defendant. So, meaning thereby, this principle is founded on the primary language of the formation of a contract, where we all already have seen at the time of beginning of this session that the performance can be given either by the person who is into the contract or any other person on behalf of the person. The roots of section 41, the roots of section 41 are therefore lying in section 2 and 3 of the Contract Act. This leads us to another important element in the Contract Act. And you will excuse me because the Contract Act itself being required to deal with in 1 hour and 50 minutes is challenge, of course, but I believe that that is what it is required. Now if you look at two important elements in the Contract Act is section 73 and 74 of the Contract Act. Friends, believe me, these are the remedial measures provided in the Contract Act. Section 73 and 74 talks of the consequences of the breach of the contract. I always say that whenever any right is created, the right without remedy has no value at all, friends. The Contract Act underlines one of the most important major provisions, namely section 73 and 74. If I read section 73, 74 before the people who have already known the law, it would be absolutely futile. But if I read section 73 and 74 for the people who have already known the law, it would be absolutely futile. But if I read section 73 and 74,
Hello. Sim,
who has suffered the breach?
sorry,
These are the three. Pardon?
sorry to interrupt, sir. Actually, there was some network issues. Can you repeat?
Okay. I repeat, section 73 and 74 have primarily inherently common essential ingredients, which are one, the formation of contract, two, the breach of contract, three, the person who is a party to the contract suffering on account of breach. So unless and until these three ingredients are not there, 73 and 74 would not have any role to play. So if you look at the title, compensation for loss or damage caused by breach of contract, that is section 73. And if you look at section 74, compensation for breach of contract where penalty stipulated for, that is the only difference. If I have entered in a contract with JNG, he writes that, sir, I have heard that you are a good lawyer, but you have a bad habit of not coming on time. So if you don't come in the session at 6 o'clock, for each 10 minutes, we will charge 1,000 rupees from you. I signed the document. And as usual, because of the court working pressure, I joined at 6:15. I would be liable to pay 1,000 rupees for 10 minutes and 500 rupees for 5 minutes if there is a contract in writing. And the charm of section 74, where the penalty is stipulated, the charm of the section 74 exactly reverses section 73. If there is no amount stipulated that this amount would be charged or recovered as a compensation, then the person who suffers the loss or who suffers the damage is required to prove two facts. One, the loss and its quantification, and the privilege or a prerogative of 74 is, if in the written contract it is mentioned that if you commit a breach, you will be liable to pay the specified amount which should have been specified in the primary form of the contract. That is technically known as liquidated damages, the amount of damages visually liquidated in advance and specified in the amount of the contract. The language of section 74, and in particular these words, the party complaining of the breach is entitled, be with me, whether or not actual damage or loss is proved to have been caused thereby. So meaning thereby actual loss may not have occurred, but because it is stipulated in the contract, I will be liable to pay rupees 1500 to Mr. Jayan because I have agreed and written a contract that if I don't join the Sambha initiative training program at 6 o'clock, for each 10 minutes, I would be liable to pay compensation of is 1000. 15 minutes, I would be liable to pay 1500. Actually, there may not be any loss because Mr. Jayant realized that Mr. Sumant is a lawyer and lawyers have a tendency to always do delay, seek adjournment, Jai Ho Order 17 key. So therefore, actually there is no loss because all the participants were there in the screen. There was very nice, healthy discussion going on. As such, there is no loss. But language of section 74 says that a person who is the party complaining of the breach, apply this example, Mr. Jayan is entitled whether or not actual damage or loss is proved to have been caused. So you are not required to prove the actual loss provided you are careful that in a contract you write it. One element of both common 73 and 74 is the element of duty to mitigate. Duty to mitigate means you cannot use the provision of the contract act as a lottery. I have entered in a contract with a traveling passenger car supplier because I am required to travel at different places in Gujarat for my litigation management, and there is a clause that the car passenger service provider shall be providing the car in the morning at 8 o'clock in case if the traveling is beyond Ahmedabad, at 9 o'clock if it is to go to Ahmedabad, and Ola or Uber doesn't provide the car at 8 o'clock or 9 o'clock, I call Pawan Hans helicopter and travel from Vadodara to Ahmedabad by helicopter and tell that please pay me the amount payable, chargeable to Pawan Hans, not maintainable. You should mitigate the loss. Giving an example, 15 minutes delay on my part in joining. Mr. Jayant should immediately tell to the participants that you may wait or you may leave. After 10 minutes, Mr. Sumant is going to join. So therefore, the loss is being mitigated. Duty to mitigate is envisaged by Section 73 of the Contract Act. And last and the important, the parameters of quantification of the compensation is on the primary principle that the person who suffers the loss, the person who is suffering the damage should be restored back to the position to which he would have been if the damage would not have occurred. So the word used is natural and reasonable. The honorable judges are the people who are conferred with the privilege to identify and apply the quantification of loss. It should be reasonable. Don't ask me what is reasonable. It is unreasonable to define what is reasonable. That depends upon the factual matrix of each case. This brings an end to the discussion on the Contract Act. You will excuse me for not dealing with the indemnity or guarantee or agency. Of course, I am tempted to quote agency is one of the important element which I believe requires a reference. Agency is very specifically what section 186 says, the authority of an agent may be expressed or implied. So this contract of agency, what we are popularly knowing, the contract of agency, the advocate being engaged by the client, the power of attorney being given by the person to another person on his behalf, these are the examples of contract of agency. You must all be aware that the agency, therefore, nothing but when you do not have your own ownership of the rights in law, somebody owns the rights in law in respect of some property and he gives you the power to act on his behalf. That is contract of agency. I must give you reference to one applied element of the contract of agency. The agency can be terminated. The termination of agency requires two things: communication of termination to the agent and to the world at large. The classic manifestation of the termination of agency is the dissolution of partnership, section 12 maybe, or maybe section 9, or maybe section 10, which says every partner is an agent of the other partner. If there is a dissolution or a dispute, the partnership is required to give a notice that the partnership is in doldrums, it is in dispute. The agency thereby comes to an end. So agency is concerned, it is being provided by section 186, if my memory serves me right. Yes, onwards. This brings an end to the discussion on Contract Act. I know that it is like showing you the trailer. No, 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 not trailer. In fact, when I was very young, I don't know whether anybody of you, there is a concept of a cinema being shown in a patrika shade. You want to see like this. This is the what process I have done. I hope I am able to justify the broad elements or the major milestones of the Contract Act. While I'll respect the wisdom and prudence to read, and I will share with you the technique to read the law. You all will excuse me. I know we all are lawmen, but remembering and devoting my most profound reverence to my senior Kailaswasi Rohit Bhai Majmudar, he taught me the technique to read law, which I'll share with you. That if I am to read the law, please don't open. This act has come into force on this date. If you open, you will not be able to travel beyond, because law is not a pure science like chemistry and mathematics. They are the applied science of law. Unless there is no life, law cannot come into effect. Therefore, he gave me the technique કે સુમંત, તમને કોઈ પણ કાયદો વાંચવો હોય તો એના ઇન્ડેક્સની એક ઝેરોક્સ કાઢી read the index list of section 100 times. You will be able to acquaint yourself with the broad energy and expression of the purpose of and the operation of that law. Believe me, that has helped me. I wish it should help you. So again, with fullest reverence and devoted namaskar to my senior, I will request you to please read the index of the Contract Act. You will be able to find out the intra-internal correlationship between various provisions. This leads us now to the Transfer of Property Act. Jan bhai, please tell me if I am exceeding time, because you know well that lawyers have a bad habit of continuously talking. But if you find that the time is getting over, please let me know.
Yes, sir, we have time. So here, most of people are judicial aspirants, so they want to listen you for hours and hours.
No, I agree with you, but then see, ultimately, I believe that I believe કે કોઈ પણ સાધનમાં શિસ્ત હોવી જોઈએ બેન. જો હું એ શિસ્ત ન જાળવી શકતો હોઉં તો સાધનનો કોઈ મતલબ હોતો નથી. આઈ એમ વેરી ક્લિયર અબાઉટ ઇટ. એટલે મેં કહ્યું કે સમય પૂરો થઈ જાય તો મને પ્લીઝ કૃપા કરીને કહેશો. નાઉ ધીસ લીડ્સ અસ ટુ another important statute, namely Transfer of Property Act. Believe me, if you look at the conceptual constitution of the Transfer of Property Act, it has a relationship with two major concepts, namely the property and transfer. And if you read the ingredients of section 5, friends, it will shake off the traditional concept that transfer of property means the brilliant deeds, documents, registered. Yes, they are. I'm not saying that they are not relevant. I don't say that they are not required. But if you look at the conceptual ingredient of the transfer of property, I make a statement of law that transfer of property does not require anything else other than into inverted comma action a chota. And I don't say the language of the old law 1882. It says in the following sections, I'm referring to section 5. If the friends can touch on the screen the section, in the following sections, transfer of property means an act, a chota, an act correlating with the language of the Contract Act. It says when the proposal is accepted by some act, કોઈ પણ કૃતિ, કોઈ પણ કૃત્ય, કોઈ પણ action, કોઈ પણ manifested expression. Transfer of property means any act. I believe language is the mother of law. The word any is wide. Any act by which a living person conveys property in present or in future to one or more other living person, that is fine. Or, and yes, and to transfer the property. So I always say the word transfer of property in first line of section 5 is a noun, and last line of section 5 is a verb, kriya pache. Transfer of property means an act by which a living person conveys the property, and to transfer the property is to perform such act. So please understand, I have a very clear understanding that whenever you have got the document or a paper or the circumstantial corroborative evidence to show that there was an action of the transfer of property, it immediately results into a transfer of property. I am aware that in case of the transfer of property of a immovable property, there is a compulsory registration, there is a compulsory effective deed being duly stamped and duly executed in accordance with the procedural provisions as applicable to the registration act. And today probably or yesterday, the honorable Supreme Court of India has directed to the government of India and the other state governments that now if you want to register the deed, how you should do it. The how is important with the what. I am today discussing with what, as it is very clear that the transfer of property means an act of the person to convey the property. And one shade I must also bring it to your notice. If you look at the language of section 53A, part performance. This is technically a possession of the property being given, and the law framers recognize where any person contracts to transfer for consideration in immovable property by writing contract to transfer, in Gujarati banakhat satakhat, English agreement to sell, and the transferee being already in possession, sorry, and yes, to constitute the transfer can be ascertained with reasonable certainty, and the transferee has in part performance. Why the word part performance, friends? The transfer of property involves two elements, the ownership and possession. And if there is a transfer of the possession or taken possession of the property or any part thereof, the transferee being already in possession continues to be in possession apart from the contract and has done something in furtherance to the contract. So if you look at for immovable property also, an action to transfer the possession with an intention to transfer the ownership at a future date is considered to be transfer of property. This goes in integrated harmony with section 5. An action of the person, yes, it may not confer upon you the title and the ownership as recognized and respected by law, but still it will give you the protection for the proprietary rights in the property of the possession, namely the possession. And now Supreme Court has ruled recently, not very recently, but yes, the adverse possession is considered now to be not only shield but the sword too. Then if you look at it, the subject matter as to what property can be transferred, it is a list, doesn't have as such any great chemistry of understanding. Another important section which I believe requires reference is section 8, operation of transfer. Unless a different intention is expressed or necessarily implied, transfer of property passes forthwith. The forthwith is this speed, मैं चुटकी बजाई, forthwith what gets transferred, the transferee all the interest in which the transfer is then capable of passing in the property and the legal incident thereof, meaning thereby section 8 very clearly says unless otherwise agreed, moment there is a transfer, everything in that property get transferred. Though I am aware that there are people who are into the business, yes, I'm conscious the word business, they draft the document, and nothing against them, that is their profession, legitimate or their own choice. Dastavej wala and document wala, there are wala people who draft the document. With all respect, they write akash thi patal sudhi, Abraham na dave. All those things are useless because section 8 very clearly says that the moment you transfer the property, everything in the property, including the word easement is there, or right to get the rents and profits, or when there is anything attached to the earth, everything is property. When the property is a date or actionable claim, the securities, then areas of interest. So everything, when the property is transferred in the nature of money, the yielding income or income is also transferred, meaning thereby not only the property, the consequential benefits emerging from out of the existence or ownership of the property is automatically transferred by operation of law. Section 8 therefore very clearly says transfer of property results into transfer of everything attached or in consequence or resultant to the existence of the property. This is the charm. Then of course section 9 says a transfer of property may be made without writing in every case in which writing is not expressly required by law. If you look at, I told you the Contract Act. The Contract Act is nomenclature which can be used as a mithai. Transfer of Property Act is either gulab jamun or ladu, the type of the mithai. Section 8, I'm sorry, Section 9 of the Transfer of Property Act says that the transfer of the property can be oral, and thereby the oral transfer is also permitted. Section 5 and Section 9 both are integrally connected with each other. Section 5 says action of the person results into transfer of property. Section 9 says there can be oral transfer. Then comes another important area of Transfer of Property Act, which requires a special attention or you know mm, evaluation, which deals with uh, an element of rules against perpetuity, section 14. And of course these are the provisions which deals with the effect of the consequence result of the transfer. It says no transfer of property can operate to create an interest which is to take effect after the lifetime of one or more persons living at the time of such transfer, and the minority of some person who shall be in existence at the expense. This is technically the rule against perpetuity is also requiring you to understand and appreciate the concept of testamentary succession, namely succession through a testament, that is the will, and you cannot make the will which is capable to create a restriction on the transfer beyond the person living. These are some of the elements. Then also there is a provision for conditional transfer, then condition precedent to be fulfilled, condition subsequent to be fulfilled, and therefore there can be conditions which are possible to be applied. Then another important element which I believe requires an essential reference is the bunch or the family of section, namely section 44, 45, 47, 48. These are the important provisions because these are the provisions, they affect the transfer of property being caused. Section 44 is transfer by one co-owner, where one or two more co-owners of the immovable property legally competent in that behalf transfers his share. If I'm the owner jointly owning the property, and if that property is an agricultural field, 10 એકરની જમીન છે, I am owner of 2 acres. Why? Because there are 5 brothers or sisters. My father unfortunately left the world. Applying section 8 of the Hindu Succession Act, my mother is not there, my father has left and expired. We 3 brothers and 2 sisters become the joint owner. I can transfer my share of 2 acre in favor of any person, and that person can become entitled to the joint possession. That is the effect of section 44. But the exception to the rule, you must know that if there is a transfer of the property of a dwelling house, સરસ મજાનું મોટું ઘર બંગલો છે મારા પિતાજી બાંધ્યું છે, and my father left the world trusting કે ભઈ મારા છોકરાઓ બધા they will behave like Pandava, but if I am Duryodhan, I have dispute with my brother, and if I sell my property, share in the bungalow, and if I'm Joshi, if I'm Patel, if I'm Parikh, if I'm Sumant, my share, if I transfer to non-Sumant, non-Parikh, then the person who is not a member of the family is not entitled to have the joint possession, but he can ask for the partition of the immovable property. Rehenak ghar, residential bungalow, dwelling house can be transferred, but the person who is getting the transfer done, non-family member, would not be entitled to claim the joint possession. That is effect of section 44. Then important provision which I believe requires joint transfer for consideration. meaning thereby if Mr. Jayant and me, we jointly purchase the property, the principle of section 45 says that जितना रुपया purchase price में है उतना आपका right लगेगा. There is a land worth 10 lakhs. I have invested 8 lakhs. Mr. Jayant has invested 2 lakhs. He would be entitled to get the ownership in equivalent to the proportion of the price he has paid unless otherwise agreed. 10 लाख की जमीन है, मैंने 8 लाख लगाया, जयंत जी has invested 2 lakh rupees. If I mention that notwithstanding the investment of 8 lakhs, I would be entitled for the land worth 5 lakhs. It is possible. That is the effect of section 45. The purpose of 45 I find to maintain the balance between the commerce and the concept of ownership. मैंने 5 रुपया लगवाया, I will be entitled for 5 lakhs rupees of ownership. मैंने 8 लाख लगवाया, I am entitled for 8 lakh rupees. But you can make change in the terms that Mr. Sumando has paid 8 lakhs and Mr. Jayant has paid 2 lakhs. Still they will be the equal owner. That is the effect of section 45. Then comes another important section which I believe, section 48, priority of rights created by transfer. If I have transferred the property, suppose there is a 10 acre of a land and I want to sell my 10 acres, I can sell 2 acres each to 5 different owners. But if I've entered in an agreement for all 10 acres, in favor of one person, and if I try to sell the same land in favor of another person, the subsequent owner will not get any interest in the land or the property. Giving an example, I have sold and transferred the property worth 10 acre. From out of 10 acre, there is a road line, Rasta Resha in Gujarati, which is sought to be, acquired through a compensation process under Land Acquisition Act by the municipal corporation. And if that fellow is transferred with the land, naturally the municipal corporation contacts me because the land acquisition notification was notified at the time when I was the owner. I will be entitled not to claim the compensation because I have already transferred the property to somebody. This is the effect of section 48. I'm sorry, yes, 48 of the Transfer of Property Act. It says where a person purports to create by transfer in different times the rights in or over the same movable property, and such rights cannot all exist together to the full extent, each later created right shall, in absence of the special contract or reservation binding to the earlier transferee. This, I believe, requires us to have a look at section 53 of the Transfer of Property Act, which has an important element what nowadays people are doing, what you call a due diligence or title investigation. એના મૂળિયા આ સેક્શનમાં દટાયેલા છે. When you go to purchase the property, you go and meet the lawyer. Lawyer gives the public notice કે ભાઈ અમારા અસીલ આ પ્રોપર્ટી ખરીદવા માંગે છે, કોઈને કાંઈ વાંધો હરકત ઓબ્જેક્ટ હોય. Every day in and day out, hundreds of notices of the brilliant lawyers are published. The conceptual cause of the public notice or the search reports or investigation of title are lying in section 53 part 2, though not numbered as part 2. It says every transfer of immovable property made with intent to defeat or delay the creditors of the transferor shall be voidable at the option of any creditor so defeated or delayed. So person X, nothing against any particular person, will excuse me, Anil Bhai Ambani wants to sell the property and I purchase it without following the due process of title investigation, I will not be bona fide purchaser because subpart 2 of section 53 says nothing in this subsection shall impair the rights of the transferee, that is purchaser, in good faith and for consideration. In good faith, if I put a Gujarati proverb, જમીનનું મૂળ અને દીકરીનું કુળ જોયા સિવાય સંબંધ બાંધવો નહીં. You will please excuse me, this is purely a social chemistry. લગ્ન કરતી વખતે દીકરીનું કુળ, જમીન ખરીદતી વખતે જમીનનું મૂળ જોયા સિવાય સંબંધ બાંધો તમે, you will be in trouble. So if you are a bona fide purchaser having made proper inquiry before purchasing the land, the law protects you. So section 53 subpart 2 says that if you are a bona fide purchaser, your ownership and rights would be protected. 53A we already have dealt with. Then comes the specific types of transfer. namely the sell, then comes gift, and then exchange, and the mortgage and lease. Though these are the four words I always classify: sell, gift, and exchange. They are absolute transfer of property. The ownership and possession both are transferred in case of a sell, in case of an exchange, in case of a gift. I have sold you my flat in Vadodara. I hand over the possession. You become the owner of the ownership and possession both. I give you the gift. Why? Because I love you, and that is one of the important element. Non-gratuitous, without consideration. When the transfer of property occurs, that is a gift, and gift is accepted. I must give you the shade and element. In case of a gift and will, there is a common thing. You should have the witnesses, and you should have an element of the gift being accepted. These are the two major elements and features of sell, gift, and exchange. Absolute transfer. In case of a mortgage and a lease, there is a transfer of partial part of the property. If I'm an owner of the property and I want to give the property on lease, what I transfer is possession. Ownership remains with me. That is lease. In case of mortgage, I transfer the ownership. I have borrowed the money from State Bank of India. I create the mortgage by deposit of title deeds, or otherwise the mortgage through equitable mortgage or English mortgage. I transfer the property. If you look at the language of section 58, a mortgage is the transfer of an interest in specific immovable property for the purpose of securing the payment of money advanced or to be advanced by way of a loan. So property's ownership is transferred. The Securitization Act comes into force. If the borrower doesn't repay the loan, the creditor has the property's ownership in its pocket. He will go and sell the property. That is, the property's ownership is transferred is mortgage. Property's possession transferred, it is lease. So mortgage and lease is a partial transfer of property. Sell, gift, and exchange is absolute ownership of the property, absolute transfer of the property, wherein the possession and ownership both are being transferred. I must give hurried reference. Section 55 of the Transfer of Property Act deals with the rights and liabilities of the buyer and seller. They are all physical, operational, material fact. If you look at the mortgage, there are different types of mortgage, and how the mortgage is to be redeemed, how the mortgage can be foreclosed. These are the two major elements of the mortgage. So far as the redemption of mortgage, it is a right of the person in whose favor the mortgage is caused, and the foreclosure is another important element which deals with. I'll request you to kindly acquaint yourself, as they are one of the major important elements of mortgage. Then comes an interesting element, I must tell you. When I was a student of law, basically I wanted to be part of the defense in army, but my physical situation did not permit me. But when I read the law, there was a concept of marshalling securities. I said, ये marshal क्या कर रहा है law में? That is how it opened an interesting reading in section 81. And marshalling opened that it is one type of transfer. Then I went to the other type of transfer, that is a mortgage is one type, sell, gift, exchange, lease are another type. That is how it unfolded the provisions of law into my interest. This leads us to another important concept which is known as lease. I must tell you that though it is not part of the curriculum, but lease and the license, there are two sides, like ma and masi. When the interest in the property is transferred with the possession, it is lease. When the interest is not transferred, but still the property is being allowed to be used, then I know there are many students who are living in the paying guest hostels or university hostel. You are allowed to use the property. You cannot use the property with some interest in the same. That is the material difference between lease and the license. And therefore lease, as I have told you, it is a transfer of property. Only a lease as the possession is transferred. And then this leads us to exchange. I have got a flat in Malabar Hill in Mumbai. I can give you that flat in Malabar Hill in Mumbai. You can give me the big piece of a land in Vadodara. because Vadodara land will be cheaper than the Malabar flat hit, Malabar Hills flat. This is what the effect of exchange. You must know well that gift is also one of the important element which says that gift is required to be accepted. Because please remember, friend, gift is a non-gratuitous, non-consideration transfer. Therefore, section 122 says acceptance must be made during the lifetime of donor. It should be accepted unless the acceptance is not express. Gift is my voluntary action. I hereby gift you the property. Unless you don't accept, the gift is not complete. So that is one of the important ingredient and gift. Then comes another area which is known as actionable claim. If you look at the transfer of actionable claim, with or without consideration shall be effected only by the execution of instrument in writing. Actionable claim is nothing but the right to enforce the claim in the commercial world. That is an actionable claim. That is one of the type of the transfer of property act. This leads us to the last and important element of our today's topic, namely the limitation act. If you want to understand the spirit and soul of the limitation act, the soul of limitation act lies in section 3 of the limitation act. It reads in this fashion: subject to the provisions contained in 4 to 24, to which I will come in next few minutes, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed. Under note this word, although limitation has not been set up as defense. So probably law framers also were aware that this is a wonderful profession wherein the law is taught in the law colleges, law is being used in the courtrooms and legal battles. But it says even if the limitation is not raised as a defense, it will be made applicable by the court. So law framers were aware that when my father paid for the fees, I bunked the clause of limitation. As a lawyer, I don't read the Limitation Act, but because Limitation Act is a statute, the fountain source whereof is an equity manifested by the maxim, he who slips on his right loses the right. The remedy is required to be enforced. So Limitation Act eliminates the remedy and not right. That is the principle. I have advanced 5,000 rupees to my friend. He has given me the promissory note or the check. I don't use the check or the promissory note in a time limit. The the Reserve Bank of India Act provides that I must negotiable instrument act provides for I must use the check in a specified time limit. If I don't use that particular check in a specific time limit, the check becomes non-usable, meaning thereby I have a promissory note. I made a demand to my friend that please pay me. I make a demand of 5,000 rupees. He doesn't pay. Within 3 years, I'm supposed to take the remedy in law. So Limitation Act kills the remedy, not the right. So my friend, I'm not entitled to initiate against him a case in the courtroom, but right is still alive. Down the line after 5 years, my friend may have a kind of a wisdom and he believes that no, the chartered accountant maintaining account is not good. The Chitragupta's account is more important. He comes and pays me 5,000 rupees. That Mr. Suman, I am supposed to pay you 5,000 rupees. I cannot say that the Limitation Act now prohibits me from receiving the payment. After 3 years, the right remains alive, the remedy dies. I cannot go to the court of law. Does not mean that I can go to the antisocial and make a recovery पठानी उगरानी. I can go to द्वारका also and request to the Lord. भगवान को प्रार्थना कर सकता हूँ कि भाई 3 साल हो गए उनको बुद्धि देना and he may pay me. So principle of a limitation act, it kills the remedy and not right. It creates the bar of law for enforcing the right to remedy, and therefore limitation act is technically I call the fusion of the substantial and procedural law both. Why? Substantial law is always providing for the element of what, the procedural law deals with the element of what. I'm sorry, the procedural law deals with the element of how. So how I am entitled to recover the money is prescribed by Limitation Act. But this is a unique law which prescribes the procedural law when to file a when to file a case is the limit given in the schedules and articles. And therefore, if you don't file a case or a litigation in a specified time, you lose the right. Best example in CPC, Order 7, Rule 11, Sub Rule E, which says when the plaintiff is barred by any law, which includes the Limitation Act, your claim can go home. So this is the procedural law having an adverse impact on the substantial rights of the person only because he doesn't file a case. This is the broad principle of a Limitation Act. The exception is provided in Section 3 that whenever any suit, appeal, application is filed after the period of limitation, the same will be dismissed, not because it is bad in the substance, but because it is bad in the Limitation Act, and therefore the suit can be dismissed. Exception is given in Section 4 to 24. Of course, I can read the section, but I am sure the August gathering before whom I am, I can always request to read, but example to explain the principle. Section 4 to 24 are the sections which are capable to convey the meaning and the message that continuous period of limitation or its running is suspended because of the statutorily recognized incompetence. If you read the basic language of the Contract Act, person has entered into a contract with my father, and unfortunately my father left the earthly world in 2006 when I was a minor. And hypothetical example, I was not minor but giving an example. So my father has a promissory note in his hand. You correlate this language, this example, with the legal representative as defined in Section 2 of the CPC. So my father left behind the actionable claim of recovering rupees 2 lakhs or 20 lakhs from the person who has signed the promissory note. My father left the earthly world in the year 2006, and in the year 2006 my age is 5 years. I do not have my mother because she also has left the earthly world, and I become major in the year 2017. From the date when I become major, my right to file a suit starts within 3 years, not from the date when the promissory note is executed, not from the date when it becomes enforceable, but from the date I become major. So the provisions and the principles of Section 4 and 24 says the period of limitation will be under animated suspension because of some incapacity of the person. There is an example that a person has a promissory note. It becomes payable in the month of December 2022. In the month of November, the person in whose favor the promissory note is given becomes mentally insane, mentally incapable, and his mental insanity under the Mental Health Act or the Lunacy Act, the old Lunacy Act, he becomes mentally insane, and insanity continues for 7 years. Entire 7 year period will be excluded from the limitation. This is the example I am giving to you to make you understand limitation period and the prescription of the Limitation Act. What is the limitation period, how it is to be computed, are provided in the principles as provided in Section 10, 11 onwards till 24. One underlying principle you all must know well, that once the limitation period starts, it runs continuously unless being accepted. EXCEPTED, मैं अंग्रेजी की यहाँ पे भाषा लेक्चर नहीं ले रहा हूँ, but because English is a poor language, it is never pronounced that it is written. So exceptions are provided. The period of limitation runs continuously unless there is an exception provided. Another important feature for the relevance of the period of limitation being renewed, I have got a promissory note executed by Mr. Jayant in my favor. I demanded in the month of 22, the limitation period will be over in the year 2025. The promissory note is executed in January, payable on demand in the month of December. I demanded, Mr. Jayant refused to pay. My limitation for filing suit for the limitation for the recovery of the promissory note is 3 years from the date when the demand is made and the payment is denied. So limitation period would be over in 22, 23, 24, 25 December. But Mr. Jain comes and tells me that, Mr. Suman, I'm really running short of funds. I assure you that I'll pay you in next 5 months. And before the expiry of the period of limitation, he signs an acknowledgement. An acknowledgement is capable to give renewed fresh limitation period from the date of acknowledgement. Acknowledgement can be in writing, or I may have 50,000 to be recovered from Mr. Jayan. He pays me 5,000 rupees. It is an acknowledgement by part payment, acknowledgement in writing. So acknowledgement is one of the important concept which I believe requires a reference. Last on the list, the adverse possession is the concept, the roots and the soul whereof is lying in part 4. Acquisition of easement by prescription, acquisition of ownership by possession, that is adverse possession. If you look at it, the ripening of the process to acquire the interest in the ownership or the possession is with the calendar continuous period of the running period of 12 years. I must at this juncture sensitize you. The adverse possession concept gifted by bogus Britishers is 12 years. If you open Mimamsa rule of interpretation, it is 25 years. The 25 years is the period because Ayurveda believes that a person here is bound to live for 100 years. So 25 years is Brahmacharya ashram, 25 years is Grahastha ashram, 25 years is Vanaprastha ashram, and last 25 is for Sannyas ashram. I know it's very difficult nowadays, but therefore Mimamsa rule of interpretation also provides for the adverse possession in case of Mimamsa rule, Oriental law in this nation, namely Bharat and not India, the adverse possession period is 25 years. Britishers gave us 12 years. We are still following without any logic. And I must also tell you, Mimamsa rule of interpretation provides that adverse possession would not be applicable, not 12, not 25, many years if the property is belonging to a woman and a minor child or dharmadhikari, namely public trust. So this was a rule of adverse possession in Mimamsa rule of interpretation. तो कोई मुझे ऐसा न कहे कि ब्रिटिशर आने से पहले हम यहाँ पे स्नेक चार्मर थे, हम यहाँ पे वी वेर एब्सोल्युटली इलिटरेट, ऐसा बोलने वाले लोगों को मीमांसा रूल ऑफ इंटरप्रिटेशन पढ़ना चाहिए. Adverse possession in India, I'm sorry, in Bharat was 25 years. In limitation act it is 12 years. So these are the two major. The easement and adverse possession are essentially integrated on the element of time, its continuous running passage of time. So therefore limitation is the law which has an essential relationship with the clock and calendar. When it moves on, it creates the positive right in your favor, not because you are doing some overact, but because the continuation of physical possession between the person and the property. I repeat, માણસ અને મિલકત વચ્ચેનો સંબંધ અને કેલેન્ડરના પાના ફરવાથી નિર્માણ થતા હક્કો is easement and adverse possession. That is one of the major element being dealt with by the Limitation Act. In addition to prescription of time limit being given for invoking the remedy in law, which remedy can be killed if you don't take an action in time. I believe this should be able to suffice the purpose of my being with you. मेरा आपके साथ जो संवाद हुआ मैं उसको लेक्चर नहीं कहूंगा, because I believe that it's not the right process. I am here to share my thoughts. If my thoughts are capable to help you to expose and understand the broad elements, the essential salient features, I believe I have served the cause for myself and Almighty God. Sarvetra Sukhina Santu, Sarve Santu Niramaya, Sarve Bhadrani Pashyantu, Ma Kashid Dukhamapyat. Namaste. Thank you very much. Namaste. If any time the God permits, we can travel together in a longer journey called law, and of course, the longest one in life. Please note, if anybody would like to connect with me, either in law or in life, I am accessible on Vidhi underscore Avadhut at yahoo.com. I repeat, Vidhi underscore Avadhut, A for action, V for actory, V for victory, again A for action, D for Dandavat, H for Hindu, double O T, T for Trambak at yahoo.com. Please reach to me. Of course, uh, Chayanji is there, Sambhav is there, Hiranshi madam is there. You can always reach to me through them. Baki, let us look forward to meet again anytime required. Namaste to all.
Thank you, sir. So, we just want a few questions which are there in the chat box. And so, thank you for your excellent knowledge sharing instead of, I can say, session. So, whosoever any question, they can ask directly to the sir. Now you can unmute yourself. Sir, meanwhile, there are two questions in the chat box. That, sir, can you explain Section 27 of Limitation Act?
Section 27, extinguishment of right to property. At the determination of the period hereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished. This section is manifestation of the primary concept of adverse possession. You open the article applicable for recovery of possession. It is generally prescribed for 12 years. If you look at the provisions of um, just a moment. Suits relating to immovable property, that is provided in part 5. If you look at article 65 for possession of immovable property or any interest therein based on title is 12 years. So section 27 manifests that for 12 years, if you do not take an action, then you lose right to recover the possession. And the Supreme Court judgment delivered before some, maybe a few years before, earlier adverse possession was permitted to be used as a shield, not as a weapon. But now Supreme Court has expanded the scope, and it says that section 27 says, at the determination of the period hereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished. Meaning thereby, if you don't file a suit for recovery of possession within 12 years from the date when you become entitled to claim the possession, the person in possession becomes owner in the conceptual title of person holding adverse possession. And as a Supreme Court judgment, it confers upon him now a right to claim the ownership, but only qua the owner who has failed to take an action. So section 27 is nothing but the manifestation of the soul spirit concept of adverse possession. Meaning thereby, the possession become adverse to the owner of the property. He is not entitled to claim the ownership and the possession, because you have allowed somebody to be in the possession of the property. Now please don't ask me question कि सर पीओके को एडवर्स पोजीशन लागू होता है क्या? उसको कुछ नहीं लागू होता.
Sir, there is another question that can Limitation Act provision is applicable in NI Act?
100%. There is no doubt about it. In fact, NI Act itself also provides for the provisions of the Limitation Act. This is the question which I believe the person must read the primary language of section 138. Within the specified time, you are supposed to take an action. So Limitation Act per se is in fact incorporated in the language of section 138. So Limitation Act, by virtue of the Limitation Act, if I ask you, if I answer this question, suppose if there is some order passed in the complaint under 138, you want to file a revision under old CRPC 397, now 483. The Nagrik Samhita, you are required to follow. So therefore, Limitation Act Limitation Act is a kind of a larger umbrella. If you ask a question, the answer to this question lies in, if you read the language of article, yes, suits me. Just a minute. If you open part 1, the applications under the criminal procedure code as is prescribed under part 1. So therefore, if you look at it, the Limitation Act is 100% applicable. And if you go to the old CRPC, it says that the complaint also can be lodged within the period of limitation, which broadly was in similar line period with the time of the punishment. So if there is an offense of the theft, what is the punishable time? What is the punishment of the imprisonment? For example, if it is 1 year, then your complaint has got to be filed within 1 year. So Limitation Act is applicable to 138 and even other criminal law provisions applicable to the criminal offenses.
Hello, sir.
Yes, please.
Sir, kindly explain Limitation Act Section 25, 26, and 30 in brief.
Okay. Section 25 talks of acquisition of easement by prescription. So this is the section, my friend, which has an essential relationship with the Easement Act. So unless you will not read the Easement Act, but I will explain in one line. What is easement? Easement is a right you are exercising on somebody's property. For example, your open plot and my open plot we acquired together. And on my southern side, you have a property. You are in US. You are not interested in constructing the property today. But our property plots are adjacent to each other. They are practically physically connected with each other. आपकी और मेरे plot की boundary is like this. If I show it on a paper, right? So this is the boundary, and I construct the exposure window and entry. I have created 2 entries opening on your plot, and I continue to have the window and the door opening and walking entering into your plot. I used it. I created the facility of window, exposure, door, entering and walking on your plot. And after we both purchased the plot together in the year 1990, from 1990 for 15 long year, that is the easement by prescription. I'm not going into other easement because your question is qua limitation act. 15 साल तक मैंने continuous period of 15 years I used your plot, and every year in the vacation you come to Bharat, and when you come to Bharat, you sit with me in a drawing room. We stand in that particular doors and windows. Then you have a knowledge, because the Easement Act says when any easement is used openly and continuously within the knowledge of the dominant owner, I'm sorry, servient owner, you are serving the cause of my dominant ownership of the easement, not the property, and you did not object to that door and window. After 15 years, my easement to enter into open land and walk through your open land, right of way, right of air, right of light, they become the matured easement. So therefore, section 25 says where the access and use of light or air to and for any building have been peaceably enjoyed therewith an easement and as of a right without interruption for 20 years. I'm sorry, 15 and 20 is 20 years. मेरा जना mathematics के साथ वैसे भी जना problem है. 20 years, and where any way or water course is used as a easement has been peaceably and openly enjoyed by any person claiming thereto an easement and right without interruption for 20 years. I gave all the examples to you. You come from America, sit with me. We have a photograph in that window. You are aware about my window. You are aware about my entry gate. Then, therefore, you are prohibited from claiming any restriction. giving the same example, you are having the boundary like this, and I have a window, which window you cannot tell me to close. So meaning thereby, section 25 is a bridging section with the nature of a particular easement, namely easement by prescription. Then you ask 20, 25, 26, right? Where any land or water upon over or from which any easement has been enjoyed or derived has been held under or by virtue of any interest for a life in terms of years exceeding 3 years from granting thereof, the time of the enjoyment of easement during the continuance of such interest shall be excluded in the computation of the period. I'll give the example. हमारा और आपका दोनों का प्लॉट है ना, वो हमारे पिताजी का था, हमने उसको डिवाइड कर दिया, एंड वी डिवाइडेड, एंड देयर इज एन एग्रीमेंट बिटवीन यू एंड मी कि आप अपना दूसरी तरफ का रास्ता जब तक चालू नहीं करते हो तब तक यू कैन यूज इट फॉर कमिंग 3 years. ऐसा एग्रीमेंट है. I am giving you the example to understand the principle of section 26. There is an agreement between you and me. You and me, we are brothers, having divided the property, and we entered an agreement that till I don't open my another gate, I will continue to use it for 3 years. And after 3 years, the period of 20 years is not getting completed. So what happens? After 3 years, unless additional 20 years are not completed, but after 3 years, only 17 years are completed, those 3 years will be excluded because those 3 years are by virtue of the agreement and not by way of easement. But after 3 years, additional 20 years completed, then only easement would be matured. I hope I am clear with the explanation to make you understand.
Yes, sir.
Okay. Then 30 you
Last,
asked, right?
last section 30.
Provisions for suits for prescribed period of limitation. I am sorry, prescribed period of Indian Limitation Act. Provision for suits, etc. for the prescribed period is shorter than the period prescribed in the Indian 1908. ये जो है ना नया लॉ आया 1963, उसके पहले 1908 वाला लॉ था. So when this 1908 law started overlapping with 1963, the provisions of section 30 provides the mechanism how to avoid the conflict between 1908 law and 1963 law. Of course, academically is good, but good for the law colleges, not for the courtrooms. क्योंकि अभी 1908 law का अस्तित्व ही कहाँ रहा. So when there was a competition, conflict, overlapping, confluence between 1908 law and 1963 law, this provision provides for the regulatory mechanism how to ensure the harmony or a committee between two different laws. I hope I am able to answer your query.
Yes, sir. Thank you, sir.
Sir, I have a doubt.
Hmm.
Sir, in limitation period for filing a suit for specific performance of a contract, in
Hmm.
case of a continuing breach, it is calculated from the date of last breach, first breach, or the discovery of the breach. And in this case, it is under which section? It will come under section like Article 54 or some other article. A
See,
suit for specific
first,
performance of a contract in case of a continuing breach.
see, when you are using the word continuing breach,
Yes, sir.
with full reverence to the language you are proposing, Benji, I will not endorse that because so far as the specific performance of the contract is concerned, it has a very, very clear and a very specific mandate, and that mandate is providing two ingredients or two contingencies. One, the breach occurs, and the breach, just a minute, I'm opening that particular language. '54, for specific performance of a contract. When you are using the word continuing breach, that language is not provided for. The continuing breach can be available for claim of compensation. but specific performance is concerned, the date fixed for performance, उसके लिए तो कोई चर्चा की जरूरत नहीं है, right? Or when such date is not fixed, the plaintiff has noticed that performance is refused. You please understand, when the performance is refused, उसका आपको knowledge आया. I'll give the example. I have an agreement to sell entered into with you for selling of the plot of a land or a bungalow or the flat, and it is stipulated that you will get the sale deed executed on or before 31st of December 2025 if you readily make the payment as per the schedule given. Now on 31st, you write a letter to me that Mr. Suman, I am ready to get the sale deed executed. And on 31st, I write it to you that I am not available. I'm in Singapore, I'm in US, I'm in Shimoga or Hampi, and I'm not available. That's not refusal. In the month of January, again you write a letter to me that Mr. Suman, now you must have come back to Baroda, Ahmedabad. Please execute the sale deed. I said, Madam, I believe that social circumstances of my life have undergone a change. So we may have to review our decision to complete the transaction. This is refusal. So limitation period of 3 years is from the date of refusal. Another example, in the month of December, the transaction should have been completed. In the month of January, you come across a public notice. Flat number C201, Sanskar flats is proposed to be sold. This is a refusal by conduct. Now, your part, if it is a continuing breach, that in my opinion is not envisaged by Article 54, which says if the date is not fixed, the date is the date on which you have notice of the refusal of the performance. Continuous breach, in my opinion, has no application when it comes to question of specific performance. It may have a relationship when the contract is involving some continuous performance or giving rise to the right to claim the compensation. I hope I am able to make my opinion straight and simple.
Sir, actually, this is a PYQ, sir, and from Gujarat Judiciary itself. And the question says as it is. I've written in the chat box also, sir. The limitation period and the option says breaches only. Last breach, first breach, discovery of the breach.
Kindly read that question.
Yes, sir. The question says, sir, just a second. So the question says the limitation period for filing a suit for specific performance of a contract in case of continuing breach is calculated from the date of. The options given were last breach, first breach, discovery of the breach. The answer key which they put out stated the answer as the first breach. So I could not understand which article it is relating from, and is there any particular case also if,
No,
for
it is
example, they are
first
referring.
breach. If the answer key gives the right answer as the first breach, it is in harmony with Article 54, Part 2, when the plaintiff has a notice that the performance is refused. It is absolutely right answer.
Okay, sir.
Absolutely. So, see, I'll tell you, the first breach, meaning thereby you have got a knowledge of the first breach. That is something which is assumed in this question. So I endorse that view that yes,
And it will not be from the discovery of the breach.
of course not, because
Okay.
this is a suit for specific performance.
Okay, sir.
Thank you, sir.
Namaste.
Sir, thank you
Now,
very much.
yes, and sir, we as you always say that we all gather for the exchange of knowledge. So we just end of today's session with short prayer instead of official formal vote of thanks.
I'm so happy, slowly, gradually. કેટલી પણ પદ્ધતિઓ બદલવા માટે હિરાંશીબેન આપણે એને ખૂબ દ્રઢતાથી ચલાવી રાખવું પડે.
Yes, sir.
Thank you. I'm so grateful, feel really, mightily pleased. That vote of thanks, slowly and gradually it will leave, because I believe it is too formal and not really warranted. Anyhow, I am really grateful for
Yes.
a very good opportunity of working together. I also look forward that we collaborate for the times to come.
जी सर जी.
But all compliment goes to your team. Such a nice program for such a long time. सबको मेरा वंदन और नमस्ते.
नमस्ते सर, नमस्ते.
I'll leave the meeting now, right?
Yes sir, yes sir, yes. And participant, this program is live on YouTube also. So if you have any further query, you can contact us on our social media or on my number 7990625945. Thank you very much, sir.